Welcome to this presentation regarding Chapter 7 of our textbook. We're going to cover that PowerPoint presentation. Here we go. So let's get started. Chapter 7 is a relatively short chapter. We're about to go into a section of the textbook where chapters are a little bit shorter, and probably more importantly, there's not a tremendous amount of hard ideas in it. There's a fair number of facts we've got to learn, but it's really just a matter of spending a little time with the facts. They aren't inherently confusing or complicated like, say, a concept like hearsay or jurisdiction. So let's get started. We're going to be talking about motions today. We're going to be talking about 5 different topics. We're going to talk about motions generally. We're going to talk about how motions are prepared, how they're served, and how the other side is likely to respond to a motion. We'll talk generally about court procedures, particularly what the court is going to do when it receives a motion. And we're going to talk briefly about a few common motions that are filed. And finally, we'll talk about the topic of injunctions. Let's get started. Okay, what is a motion? This is just a definition from the textbook. A motion is a request to the court that, I have a typo here, that it do something. The difference between a motion and a pleading is primarily that a motion is requesting the court do something now. A pleading is designed to kind of go into effect or be relevant at trial. You're presenting your arguments for a day in the future. So when you file your for example, your complaint or your answer, you're really not expecting the court to do anything with that right now. It's certainly something that the court will review and the court will take it up perhaps before the trial, but certainly that's where the focus is. But a motion isn't going to be presented to the jury. It's going to be decided by the judge. And they can be big issues. For example, there are motions that are called dispositive motions that will dispose of the whole case. Then there are other more mundane motions, a motion for an extension of time to file an answer or to have discovery last longer, or perhaps to move a trial date because of a health reason or travel plans or something like that. So motions are not considered pleadings. They're documents filed with the court, and that distinction about kind of what the expectation is that the court will do with it is the primary difference. We've talked about Rule 11 before in the context of pleadings. Remember, that's the rule that puts a special onus on the person signing the documents. Well, that onus, that responsibility also applies to motions. So Rule 11 sanctions can occur with motions as well as pleadings. And again, that's the one rule number, well, there's 2 that we need to know in this course. Rule 23, which is the class action rule, and Rule 11, which is the sanctions rule. So that's motions generally. Now let's talk about preparing, serving, and responding to discovery. The rule that we look to when we discuss how to prepare a motion is going to be Rule 7. Again, you don't need to know that number. But it's good, I think, sometimes to know that there are actual rules. This stuff isn't being made up. It's not kind of being pulled out of the air. That the rule book for federal court and also for state court is quite detailed, and it really does give you a very good roadmap. So when you are doing something you're not quite sure how it's supposed to happen in federal court, the logical place to go is to the Federal Rules of Civil Procedure. So what's the first thing we need to know about motion? Well, it needs to be in writing, and that's usually needs to be in writing. We'll talk about an exception to that rule in a second. The next one, it has to state with particularity the grounds therefore. What is the reason that you ought to win your motion? You need to tell the court so the court can decide whether it agrees with you or not. And then, of course, you have to say what you want. What is it that you want the court to do or grant or tell the other side to do? What is the relief that you're seeking? What is that court order? What is that going to look like if you get what you want? Here's the actual rule. And again, as you will see, the Federal Rules of Civil Procedure are written to be quite easy to understand. So here we have it. We're in Rule 7B, Motions and Other Papers. In general, a request for a court order must be made by motion. The motion must, and here we see there's 3 items, just like we talked about 3 items over here. They're going to track very nicely. So what must the motion contain? Well, it must be in writing unless made during a hearing or at trial. It must state with particularity the grounds for seeking the order, and it must state the relief sought. Let's go up to this first item for just a second. The vast majority of motions, or what we think of typically as motions, are things that are filed with the court. But every time in a trial somebody moves, Your Honor, I move that exhibit be admitted into evidence, or I move that exhibit be excluded from evidence, or I object. All of those things are technically motions, but of course we're not going to stop trial and have somebody get out their computers and type up a motion at that time. So during a trial or during a hearing, when you're in the presence of the judge already, you do make oral motions. But even though it's still it's an oral motion, it's still a motion. So you're going to be looking at those same factors. You're going to state with particularity the grounds for what you're requesting, and you're going to say what you want the court to do. Now, sometimes it's obvious in the context. For example, you say, Your Honor, I move to exclude that evidence. Well, you're asking the court to order that evidence not be admitted so the jury can't consider it. So you might phrase it a little differently than you would if you were actually doing a written document. But at the end of the day, you're accomplishing the same thing. Okay, so what do you need along with your motion if you are submitting in written form? Well, obviously the first thing is you need the motion, and you might think that's the big thing here. But many times the motion, I mean, it's important, but it may not be the document that you spend the most time working on. The next document you're going to want to have is a notice of hearing. Not all motions require a notice of hearing. Sometimes some judges will make decisions without actually noticing it for hearing. But many judges definitely want to hear oral argument, and some judges insist upon it. So obviously if it's that type of issue and in the court that you're dealing with wants to have an oral argument, then you'll need to notice the hearing. So at this point, before you can notice the hearing, obviously you have to talk with opposing counsel, find out what his or her schedule is like. And then you typically will call the court coordinator or other court personnel that handles the court schedule and figure out when you can get on the schedule. And so that's the process that you follow. You kind of become the social director, so to speak, for that particular event. This is something that the paralegals are often involved in, scheduling everybody's schedule together. The paralegal also could draft a motion for sure. And then there can be affidavits that support the motion. Let's imagine that you want to move the trial date because the attorney with whom you're working is expected to have a baby at that time. Well, so you would submit a motion saying that you would like to block out, say, these 6 weeks and preclude those from being the trial date. Then to support that, though, you'd most likely want to include an affidavit from the attorney explaining, that she is expecting to have a baby, the due date is this point in time, and that she's been advised by her doctor that she shouldn't be in trial during that time, or something along those lines. And so that would be the affidavit to support something like that. Other times there might be other affidavits. I'm about to show you an example of that, but it's very, very common to prepare affidavits in this situation. The paralegal might draft the affidavit. Sometimes he or she might be the person who is going to be the affiant, the person who's going to actually swear out the affidavit. And many times the paralegal is also a notary, and so she may be notarizing the affidavits. So there's lots of involvement there for the paralegal. The last thing, and this oftentimes is the big deal, is the memorandum that supports the motion. Especially if it's a dispositive motion. The motion may just be a page or 2 or 3 long, but the memorandum may be 20 or 30 pages long and take a lot more effort to prepare that. And again, commonly paralegals are involved in preparing that motion. Probably less commonly than preparing the other 3, but still commonly doing this type of work. This is pretty sophisticated legal work, so it's something that, early in your paralegal career you may be less involved with than you will as you develop professionally. Here's an example of a motion. The formatting got a little bit cattywampus when I was putting it in here, but it gives you some idea of what it might look like. Here's the caption. You can see it's a little bit different in this district court, which is in Iowa, but this is an example of the motion that is being filed. Plaintiff John Smith, we can see John Smith's name right here, moves this court for an order continuing the hearing on defendant's motion for discovery sanctions presently set for July 1, 2003 for 10 days. In support of his motion, plaintiff states, and of course they would actually provide 3 arguments here, and they close with a wherefore paragraph, which is a very common way to end a motion or really any document you're filing with the court. Well, wherefore, plaintiff John Smith requests the court to enter an order continuing the hearing date presently set for July 1st, 2006 to July 11th, 2006. And you can see this motion does all 3 things that we've already just said that a motion needs to do in federal court. It's in writing. It states in particularity why its motion ought to be granted. Of course, they're actually not listed here, but the 1, 2, and 3 would fit into that category. And we can see here where we're requesting an order continuing the hearing for 10 days. And again, we restate what we're seeking right here. So we've accomplished all 3 of our tasks, or all 3 of the necessary components of a motion. And this is an example of the notice of motion. And it explains when this is going to go to hearing. And very often this might be called notice of hearing. And the caption is actually missing because this might be the 2nd page of the motion. It may not have the caption on it. That would be a local practice issue. Let's consider the topic of proof of service. Now we're going to be filing motions in federal court. We're going to be filing those electronically, but still you're going to include a proof of service. And it's a notice that usually appears at the end of a pleading or a motion, and its purpose is to show the court that you actually sent this to the other side. And many electronic filing systems will automatically send anything filed by one party to all the other parties. It not only demonstrates that it was sent and state the day that it was sent, but it also explains how service was accomplished. Was it mailed? Was it electronically sent? Was it couriered over? Those types of details. It's very important to have this document. It would be a faux pas not to include it, and in fact, very, very likely you'd be embarrassed and it wouldn't put your client in a good position to forget to put something like a certificate of service, which is the more common term for it. So here we have a motion. This is a 12B motion. This is seeking to dismiss a lawsuit because the defendant the court doesn't have jurisdiction over the defendant. So you can see here, this is something that the defendant would be filing. And we can see here, this is the defendant's name, Overland Corporation, and we see here that we start with Overland Corporation's name, and we see down here that Pat Rivas is representing the defendant, Overland Corporation. So this is the motion, and you can see it's really short. Overland Corporation, by Pat Rivas, its attorney, moves the court to dismiss the complaint on file on the following grounds. The complaint in this action alleges that this action is filed in federal court because it involves a dispute between citizens of different states. However, the court lacks jurisdiction, as alleged in the complaint, in that plaintiff and defendant are citizens of the same state, as is more clearly stated in the affidavit of Owen Young, hereto attached as Exhibit A. A memorandum of points and authorities in support of this motion is filed and served with this motion that it's stated. And of course, there'd be some differences in the way that we would file this. For one thing, we would probably, if we were in the northern or eastern district, we'd put the name down here. We probably wouldn't say by the name of the attorney, and we'd say respectfully submitted here. So there's a few subtle differences that we see. We'd also probably just put a V and a period here. Let's look at the next document. This is the affidavit. You can see that it is on a caption. That's very common when you are actually you're preparing the affidavit for the purposes of being an attachment in this sense, but it doesn't have to be. It could lack this captioning. And again, this might be something that you would draft. Let's read what an example of this type of affidavit might say. I, Owen Young, being first duly sworn, depose and say, I am the president of Overland Corporation, the defendant in this action, and am acquainted with the facts in this case, and have personal knowledge of the matters set forth in this affidavit. This first paragraph is going to be numbered. That's a common way to do affidavits, so that you can, in your memorandum, refer to particular paragraphs. You can say, this is obviously a very short affidavit. You might have an affidavit that's 4 or 5 pages long, and it's convenient for the reader to know what part of the affidavit you're drawing the reader's attention to. So this is basically setting up saying, Mr. Young is an expert. He's familiar with the facts. Often, that's very common in the first paragraph. Often in the first paragraph, there might also be a statement such as, he's over the age of 18, for example. Let's look at paragraph 2. I make this affidavit in support of the motion to dismiss the action. That's a fine addition to have to your affidavit. It's not necessary to have, though. Sometimes you prepare an affidavit earlier on and you're not quite sure how or when you're going to use it, and so you might not want, for example, to have this in here because you might decide, well, I'm going to use this affidavit for a motion for summary judgment, for example, or some other purpose. Paragraph 3. I held the office of President of Overland Corporation at all times mentioned in the complaint filed in this action. Okay. Another good thing to say, obviously. Number 4, at all times mentioned in the complaint, Overland Corporation has been incorporated under the laws of the state of Delaware. Okay. Now, reading this along, if you the only document you have in front of you was this affidavit, you might be like, well, why are you telling us this? Let's look at the next paragraph. At all times mentioned in the complaint, Overland Corporation has had its principal place of business in the state of Nebraska. The corporation maintains 4 sales offices throughout the state of Nebraska, maintains its primary bank account in the state of Nebraska, and keeps copies of all corporate records within the state of Nebraska. Business conducted within the state of Nebraska accounts for more than 75% of the total income of said corporation. So you can see here, if you go back and think about what this motion is about, it's because of a lack of jurisdiction. It appears that Mr. Jones is either a citizen of Nebraska or a citizen of Delaware. And because of that, there lacks diversity because Overland Corporation is, for the purpose of diversity, the equivalent of a citizen of Delaware and Nebraska. And so because there isn't complete diversity, Overland Corporation is saying this case ought to be dismissed from federal court. But you can see in the affidavit, Mr. Young doesn't connect all the dots. He's not making argument. He's not saying, and for these reasons, diversity doesn't exist. He's just stating the facts here. He's not drawing any legal conclusions or really any types of conclusions at all, just stating the facts. In the memorandum, the attorney will connect the dots. So this is just intended to be a list of facts that Mr. Young has personal knowledge about. Let's go to the next slide. Here's a very handy list of things to look for when you are preparing motions. It's a really good idea to use checklists. You don't have to use this checklist. There's lots of these types of tools available, but as you can see, there's several things that you need to do, and it's good as you are going through the process that it can help you not forget something. One thing that's always a good idea is to check local rules. Every federal court is going to have local rules, and if you deal with a court regularly, yeah, you probably will be pretty familiar with the rules, but if it's a court that you don't deal routinely with, then you may be surprised by the local practices there. So you'll definitely want to make sure that you check the local rules to make sure there's nothing surprising. Again, before you file it, you're going to want to check hearing dates with opposing counsel, and then you'll want to call the court, probably the court coordinator, and actually obtain a date for the hearing. And obviously, you'll want to make sure that that date is going to work for opposing counsel. Sometimes people wonder in litigation, well, why am I trying to help opposing counsel? Why do I want it to be a date convenient for him? There's a lot of professional courtesy that goes on in the law. Attorneys in court may be fairly contentious with their adversary, and from time to time they are in the litigation. But there's also a lot of understanding that we're both trying to do a job, and being unnecessarily difficult means that the other side will be unnecessarily difficult to us. And so there's really a feeling of cooperation that exists on a certain level throughout the process. And of course, another big one is that if you don't work in a cooperative manner, the judge is going to get mad at you. You don't want the judge mad at you. So definitely, when you call the court's going to say, well, what did opposing counsel say? What dates would work for the opposing counsel? And you'll feel a little sheepish if you say, well, I haven't called them yet. So you'll want to do that before you call the court. And then, of course, you want to make sure, and you probably will prepare the documents actually before you do these things. But around the time that you do these things, you want to make sure you have your notice of motion, which is probably going to be called a notice of hearing. You're going to actually have the motion. You're going to have any affidavits that you need. You're going to have that memorandum in support of the motion. There may be some other documents required depending upon the particular motion you're filing. You'll need a certificate of service, which they're calling here a certificate of mailing. and a proposed order. Obviously, there's no guarantee the court will sign your proposed order, but you want to include it in the document as a courtesy to the court. Once you have all those steps taken up to this point, you're going to be able to file your motion, and of course, you're going to serve it on all the parties. If you're the plaintiff, you're going to serve on the defendant or defendants. If there's other plaintiffs, you'll also serve it on them. If you're a defendant, obviously you'll serve it on all the other parties as well. You will obviously file the document with the court clerk, and then very possibly, depending upon local practice, you may also need to send a copy to the court's chamber so that the court will have easy access to the document. You want to make sure that the date is calendared for the attorney. Very likely you will be keeping the calendar for the attorney, and if it's not you, then it may be his or her secretary. So you want to make sure that's on the calendar. And you will, of course, wait to see what the other side says, see what kind of response the other side makes. And at that point, you will decide whether you want to respond further. Another thing that is missing from this list that is usually required is a certificate of conference. This is something that says that before you file your motion, usually you have to ask the other side, do they oppose or agree to the motion? Let's say it's an extension of time to do something. Very possible they will agree to it. And whether they agree or not, you have to tell the court the position of the side. Because obviously if both the plaintiff and the defendant agree to something, it's more likely the court will grant it than if one party is opposing it. So that's useful information for the court to have, and usually it's going to be a requirement. It's missing from this checklist, but it's just something to keep in mind. Okay, so let's say that though that your law firm isn't filing the motion, your law firm is responding to a motion that it has received from opposing counsel. Well, when you file a response, you do many of the same things you do when you file the motion. You're going to have affidavits, very likely. You're going to have memorandum of law. You're going to have proof of service. You won't need a certificate of conference, obviously, because that will have been included in the actual motion, and your response will make it clear whether you support or oppose the motion. So those are our first two steps. We talked about motions generally. We've talked about how you prepare them, how you serve them, and how you respond to them. Now we're going to talk about what the court's going to do. So the court's received your motion, and let's say the court has decided that it wants to have a hearing on it. Well, it has had the hearing, and it can decide from the bench, or actually in open court, whether to grant the motion, or it may decide in its chambers whether to grant the motion or not. If it is inclined to side with the motion submitter, the movant, in that case, he may just sign the proposed order, or very possibly he may mark the proposed order up and submit it with the markup. For example, he might add the word "not." I'm not granting this motion. I'm not giving you an extension of time. What is an order? Well, simply an order is a written command or direction given by a judge. It applies to the litigants in the case. It affects kind of what they have to do. Obviously, if you are in violation of the order, then you could be in contempt of court. The goal of the order is to resolve the dispute. It's to resolve the motion. Maybe you win it, maybe you lose it, but the matter is over, at least for the time being. Most orders can't be immediately appealed. If it's an important order, it may be possible to appeal it later on, and every now and again there's the possibility of what's called an interlocutory appeal, to appeal if it's a really important order in the middle of a case. But that's kind of beyond the scope of this chapter to talk about that. Here's an example of an order. And you can see that this is a proposed order, probably that Overland Corporation prepared, because there's some blanks. So the judge would be in a position to sign this, date this, and say the date that it was heard, and so forth. And that if the court decides to grant the motion, that it could be very quick and easy for the judge to do that. Let's see what this order says. This action was heard on, of course you'd add the date, on the motion of defendant Overland Corporation for an order dismissing this action. Pat Rivas appeared as counsel for defendant in support of the motion, and Lane Borman appeared as counsel for plaintiff in opposition thereto. It appears to the court the defendant is a citizen in the same state as plaintiff, and that therefore this court lacks subject matter jurisdiction. Therefore, it is ordered that the complaint filed herein on blank date be and is hereby dismissed. And again, it'd be dated and signed. So that's one possibility. Now, of course, the court could say, it appears that the court is not the citizen. So you could just put a little not in there, and therefore this court does have subject matter jurisdiction. Therefore, it is ordered that the complaint filed hereon on this date not be dismissed. So, it could be changed dramatically to reflect what the ruling is of that particular court. So now let's talk about some examples of specific motions. This is a list of common and really important motions, but of course, really, there's so many different things that can happen in trial. It's no way to anticipate every single motion that can be filed. And, litigants can come up with their own motions, things that haven't ever been done before. So, a common, and you'll see several of these are 12B motions. A common one is a motion for a more definite statement. This is filed before an answer is filed, and the purpose of this is to the defendant doesn't really understand what the plaintiff is saying, at least in certain parts of the complaint. Perhaps the plaintiff is pro se, and so didn't phrase things in a very legally tight manner. Or it could be that the plaintiff just doesn't have that many facts to support the claim. And so the defendant wants more details, more specifics before it feels like it can file its answer. That would be an example of a motion for a more definite statement. This relates to the complaint. Another example of a motion is to strike a pleading or allegation. Sometimes this is done when there is something shocking or disturbing or inappropriate in a pleading. Very abusive language or something like that you might move to strike it. That would be an example of that. A motion to amend a pleading. We talked when we were in Chapter 5 about the fact that you have one right, you get one free amendment if you do it quick enough after you file your complaint. But after that, if you're going to amend it, you will need to move the court for permission. And again, you'd have to a conference with the opposing counsel to see if they're willing to stip to that or not. So that's a common motion, pretty commonly granted. For judgment on the pleadings, this is also an option that we have under 12B, but it's not that common, because what is required for this motion to be granted is that if you take what the plaintiff has said in the complaint and accept everything as 100% true, what the defendant is saying if he files this motion is plaintiff still can't win because these facts don't present a cause of action. That's relatively rare to happen. The two times that it sometimes does happen is when you have a pro se plaintiff who really just doesn't understand how the law works. Or you have a probably more sophisticated plaintiff who's represented by counsel who is looking at expanding or broadening a legal concept. And so as the law exists right now, yeah, he probably doesn't have a claim, but going forward, or hopefully after this case, the law will have been expanded to cover this scenario. Okay, so that's the reasons why sometimes a judgment on the pleadings, you can have a complaint where a motion for judgment on the pleadings can be appropriate. Another would be requesting a change of venue. There may be something about this particular venue, this particular court, that is not convenient for the parties, or perhaps there's been some controversy about this matter. It's been a lot in the press, and the concern is that your client won't be able to get an appropriate trial. Another motion could be to compel a party to do something. For example, compel a party to respond to discovery requests. Or perhaps to compel a party not to do something, such as not to reveal certain documents, have a protective order regarding certain documents that are being exchanged in discovery. You can request a protective order. That's another one. That's a mechanism to keep certain parts of the litigation outside the public eye, not available to the press or to other people who don't have a need to know about the litigation. This is fairly common in protective order. For summary judgment, this is something that's going to happen not really at the beginning of the trial. To this point, at least these are very early actions, although sometimes amending a complaint can be later on. This can really happen at any point, as can this, although usually it's in the discovery mode, discovery phase of the lawsuit. Summary judgment is usually going to be after discovery is closed, because you're going to use all that good data you got during discovery to be the basis of your motion for summary judgment. In some respects, is a little similar to this one, because this is a dispositive motion. The goal of this motion is to dismiss the lawsuit. So the defendant wins. And it doesn't have to do anything more if he wins this motion. Obviously, the plaintiff may appeal it, but at least in this trial court, the defendant is finished. A motion for summary judgment is similar. The lawsuit is going to go away. Again, the plaintiff very possibly will appeal it, but it dismisses the lawsuit. The difference is, for motion for summary judgment, isn't just on the pleadings. It also considers other information that the plaintiff has presented. And so let's say the plaintiff said in his complaint that he was sober at the time of the car accident, or maybe he doesn't say one way or the other, but during his deposition he admits that he had had 5 beers in the hour before the car accident or something like that. And so then you can use that fact in your summary judgment motion to support your argument that really the accident was caused by the plaintiff. In addition to motion for summary judgment, you can also file a motion for partial summary judgment. Let's say the plaintiff has asserted 4 different causes of action. Well, it may be that you don't feel like you have a good shot at getting summary judgment on 2 of the causes of action, but you think you have a chance for the other 2. So then you might file a motion for partial summary judgment. Then the last motion on this list, again, this is not an exhaustive list at all, is for sanctions, Rule 11 motion. And this could be filed really at any point in the process, from when you first get that complaint all the way up to post-judgment matters. So those are some examples of specific motions. Let's look at injunctions. An injunction is a particular type of order that a court can grant. It is an equitable relief as opposed to legal relief. You may recall we talked about equitable reliefs. Those are the non-monetary relief that only the court can grant. Juries aren't in the position to grant this. Here's a definition of an injunction. An injunction is an equitable remedy used by the plaintiff to stop certain conduct or actions of the defendant. An injunction can work in 2 ways. It can tell the defendant, don't do this, or it can tell the defendant, please do this. And of course, because this is an injunction, it's going to be the motion that makes this request is going to be filed by the defendant by the plaintiff against the defendant in most cases. An injunction is likely to start out as a provisional remedy. A provisional means, in this context, a temporary remedy. It's something that may be requested before trial, because, of course, from the date that the complaint is filed until you go to trial is going to be at a minimum several months and very likely over a year. So one of the goals of an injunction is to kind of maintain the status quo, but a lot can change in a year. And so if something is happening in the relationship between the 2 parties, and there's no ability to kind of freeze the situation, by the time you go to trial, it may be too late to really solve the problem. Going back to my example of, Groover Gardens, the farm that was downstream of the big bad polluting company that was dumping all kinds of bad chemicals into the river and killing all of the plants in Groover Gardens. Well, if the pollution didn't stop by the time Groover Gardens gets to trial in the case, it may be so the Groover Gardens may be so contaminated that it's going to be really, really super expensive to rehabilitate the land, perhaps even impossible to rehabilitate it in a short period of time. So you want to have a provisional remedy before trial to at least ensure things don't get worse. And again, this is outlined in the Federal Rules of Civil Procedure. So you're likely to start, if you're the plaintiff and you're seeking an injunction, you're likely to start with a TRO, a temporary restraining order, which again is commonly called a TRO. So to file a TRO, you're going to have to do several things. And no one comes strolling into your office saying, you know what, when you get around to it, whenever it's convenient, why don't you go ahead and file a TRO? No, this is the house is on fire. We've got to act really, really quickly. So it's kind of an emergency situation. You hear about it at 10 a.m. and you're trying to get everything done by, say, 3. Just a matter of a few hours to figure out the facts and get all the documents lined up and get down to court in the hopes that you'll get this granted. So what are the documents you would file if you are seeking a temporary restraining order? Well, of course, you're going to have to file a complaint, because at this point, the court doesn't even know that there's a dispute. So you have to start by getting a judge assigned to your matter. And of course, eventually you're going to have a trial. So the complaint gives the court status in the matter, gives the court a connection to the case. But of course, the court isn't going to be able to resolve the complaint at this point in time. That's something down the road. That's for when we get to trial, most likely. And just like any other complaint you're going to file, you're going to need to get a summons. So you're going to do all the things that we did in Chapter 5. Then, in addition, you're going to want to have an application for a TRO and an application for a preliminary injunction. Preliminary injunction is the second phrase. We do the TRO first, then we're going to get the preliminary injunction. You're going to need an attorney's certificate of attempted notice, or maybe of attempted conference. This is temporary restraining orders are oftentimes ex parte. Let me type that word for you so you can see what it looks like. It's a Latin phrase. Ex parte, it means that the court is only hearing from one side. The court is hearing from you, not from opposing counsel. And that's not a really good position to be in. Courts don't like it. It raises questions because, of course, the court isn't in a position to hear what the other side said. The other side might have a perfectly good explanation for what's going on, and the court might well say, well, I agree with the other side, but the court isn't going to be able to hear from the other side because the other side isn't there. But you have to prove to the court you at least attempted to talk to either them or their attorneys. And then at least you have the ability to have the ex parte conversation with the court in open court, in a public forum, so that the court can consider the facts as they exist. You may have live testimony at the hearing, but you may also want to have affidavits attached to the TRO so the court can see, okay, there seems to be some basis here for it. It's worthy of my consideration. You may need to provide for security costs and damages. If the TRO is granted and it ends up that you really didn't have a legal basis for it, and the other party, the defendant, has been financially injured as a result of this, the court very likely will require that you pay. If you're shutting down that other person's business, that you pay for that. And then, of course, you want to have a draft of that court order, your proposed court order, your wish list of what you want the court to do. May not get it, but if you don't ask for it, you're probably not going to get it. So you're going to go ahead and ask for it. So that's the TRO. I guess I don't have a slide on preliminary injunction. Let me talk about how that works. So let's say the court grants your TRO. It's an emergency situation. You got to do it right now. The pollution is happening as we speak. So the court grants the TRO, but the court isn't going to allow that TRO to last very long because it's ex parte. We haven't heard from the other side, and it's really not fair to the other side that they haven't had their day in court. Of course, they'll eventually have their day in court when we get to trial, but that's a lot of months in the future. And so as quickly as possible, the court is going to say, we're just going to allow this TRO to last for a little while, and then we're going to have a hearing on the possibility of a preliminary injunction. And both parties will be present, and both parties can make argumentation, and both parties can present witnesses. And so we won't be, when we're in the preliminary injunction phase, we won't be in the ex parte environment. Both parties will be there. And of course, it will allow both parties to have more time to prepare, to research the law better, to find more witnesses. So it's a much more robust, thoughtful, deliberative process. And at the end of that hearing, the court can decide whether to convert the TRO into a preliminary injunction, or to not even have a preliminary injunction and just dissolve the TRO, or to institute a preliminary injunction that somehow is different than the TRO. And then that preliminary injunction will stay in effect until the trial and until there's a final resolution of the dispute. If the court decides at that final time that there needs to be a permanent injunction, then the court will issue that permanent injunction, which will essentially stay in effect for an indefinite period of time. So those are the three stages. TRO really quick, within hours or days of when the issue arose. Preliminary injunction just a little bit later, within some days, maybe a week or two after the TRO. And then the permanent injunction, of course, if it's granted, will be after trial. So that's months down the road. So that's the process for a special type of motion, the motion for an injunction. So I think that we've covered all of our topics today. If you have questions, please be sure to bring them to class. I'll be delighted to answer them for you. Thanks for your attention and see you soon.